Today we have joining us Justice Deepak Gupta, former judge of the Supreme Court, who's been a part of the highest institution, judicial institution in the country. And he's here to talk about the long-standing face-off that the Collegium and the Centre has been facing with each other. Thank you, sir, for speaking to India today. Just to get your initial thoughts on whatever you think is going on. Today, in the most recent statement, the law ministers criticized the fact that the Collegium, in their recommendations recently, have put out details about the IB and the R and AW reports that the Centre had communicated to the Collegium regarding appointments to certain high courts. So what are your thoughts? Where do you think this entire tiff between the two, if I can call it, is heading now?
Well, I think it's not merely a tiff, it is more than it's almost like a head-on collision now. It's not merely a tiff. And I say this because it's not one odd statement, one-off statement coming once in a while from some repeatedly constitutional authorities are criticizing either the Collegium system or now somebody has taken pot shots of the basic structure doctrine also, which has been sacrosanct for so many years. So I think there's a little more than just a mere tiff. Having said that, on the one hand, the Honorable Law Minister said that the proceedings of the Supreme Court are opaque. That was a couple of weeks or a month back. And they lack transparency. And when they are transparent and give the reasons why they differ with the government, then he says, this is also not proper.
Do you think the government...
What is it? And I've always, and I've said this earlier also, that as far as opaqueness is concerned, I'm also against opaqueness. The proceedings should be as transparent as they can be given the circumstances and the post to which the people are being elevated to. But if you want transparency, then there has to be disclosure of the reasons. Especially when the government... Sorry. Please go ahead.
So what do you think is the reason for the government and like constitutional bodies like the Vice President himself making these repeated public statements while also in the same breath telling the Supreme Court judges that judicial posturing from public platforms is not a good thing?
See, we have a system of separation of powers. And in the system of separation of powers, which is a system of checks and balances, each wing must respect the other. I am clearly of the view that this public posturing, this war through the media, taking pot shots at one another, especially by the government against the judiciary, is not called for. Judges normally speak only through their judgments. But when sometimes very harsh things are said, and said by people who hold very high constitutional posts, judges have no other option but to answer. And the answers were given by Justice Kaul during court proceedings. He did not do so by going to the press or anything. During court proceedings, and he conveyed his angst, his sorrow to the Attorney General, who is the law officer of the country. Therefore, I see nothing wrong with it.
But at the same time, the Vice President very clearly said that he refused to entertain the Attorney General when the Attorney General came to him with a message.
So, see, that is his choice. One can't force the Vice President. He's also a senior lawyer. He can. You see, I'm not saying that everybody must agree with the point of view of the government or my point of view. In a democracy, that's the beauty of a democracy. We all may disagree with each other, but we must disagree in a civilized manner. We must have a debate. We can agree to disagree, but we can't, try to deride an institution. And for me, this constant effort over the last 1.5, 2 months seems to be a systematic effort to undermine the independence and the strength of the judiciary.
But in your opinion, do you think the system itself requires a change? Because that is the question that is being brought up again and again.
Why should we ever be resistant to change? Nothing is perfect. And if the system can be improved, why not a change? I'm never against a change. In fact, if society remains static, that is the worst sort of society.
So in what way do you think?
No, if you talk about, let's talk about the thing about the main is the Collegium system.
Yeah.
See, and why did the Vice President talk about the basic structure? My feeling is he talked about the basic structure because one of the features, one of the factors which has been held to be the part of the basic structure of the Constitution is an independent judiciary. In a democracy, there can be no democracy without an independent judiciary. So if judiciary has to be independent, there has to be a proper method of selecting judges.
So on this,
please complete. You see what, to counter the Law Minister and the Honorable Vice President have been saying that this is not found in the Constitution. They are right. But why did this come? There are three judgments: Judges Case 1, Judges 2, Case 2, and Judges Case 3. And in all these, the courts held that since an independent judiciary is a fundamental right, and we must remember that the state is the biggest litigant in this country.
Yeah.
They give example of other countries, but there the state is not the biggest litigant. In our country, the state is the biggest litigant. I'm not talking about criminal cases, I'm talking about other cases also. The state is one of the biggest litigants. So therefore, can the litigant choose the judges? I mean, you can put the question the other way, but that is not. It's a constitutional scheme of saying, as the law stands today, the Collegium system has to be followed.
But
in my view, it needs improvement. And if the government wants to change the system, then nothing which prevents them from bringing in a new amendment. And that will be tested on the touchstone of the basic structure.
No, so my first question rather is that why are we assuming that the government having a say will in any way compromise the independence of the judiciary when prior to 1993, that was what was happening? And we saw some of the greatest judges who've come to the Supreme Court during the time when government was single-handedly appointing these judges.
You see, I'm just preparing. Dr. Ambedkar said in his speech on 26 November 1949, when the Constituent Assembly was adopted, the Constitution. I mean, since I'm saying it without looking at the speech, I can tell you, you can have the best system, but if the people are bad, that system will not work. You can have the worst system, but if the people are good, it will produce results. See, who says that the government has no role? Even today, the government has a role. When only thing what has changed is, you see, you say 93 or before, see, prior to 73, when the first two case of supersession took place, when Justice Shelath and Justice Hegde and Justice Shah were superseded in 1973 after the judgment in Keshwanandan Bharti's case, and Justice A.N. Ray, Justice A.N. Ray was appointed Chief Justice over them. All the judges were appointed by the government. But please remember that all of the names were sent by the Chief Justice without any interference by the government. Between 73 and 93, we saw another era where the government had primacy and the judges were not being heard that much. And if you took 73 to 93, it's a different aspect. I'm not saying all the judges appointed during this period were bad. You see, you don't need all the judges to be bad. You just need a few bad judges, and it spoils the name of the judiciary.
There was something very...
It's not that the government... I'm not saying that the government if we all work for the constitution, we take an oath, whether it's the ministers or the judges, we take an oath to uphold and protect the constitution. If we are true to our oath, nothing will go wrong. But as on the ground, I have seen as a chief justice, as judge, every government, it's not only the BJP government, whether it's a Congress government or I've seen a communist government, everybody wants to pack the courts with their men. And if that is allowed to happen, that will be the death knell of the independence of the judiciary.
Just yesterday, we spoke to a former Delhi High Court judge, Justice R.S. Sodhi, who actually made a big statement when he said that because of the kind of the system that exists today, high courts are no longer independent. In fact, he went on to call the high courts have become spineless because the judges in the high courts are constantly looking towards the Supreme Court to get appointed there. And judges who've come to the Supreme Court from high courts are picking their favorites from the high courts. So there is politics within the judges also regarding these appointments. Would you agree?
No, I am not going to. I don't agree to the extent Justice Sodhi has gone. I mean, I feel he has used some, the words also are rather harsh. But I'm not saying these things are happening. And that's why I say the Collegium system also requires to be improved. I'm not saying that everything is hunky-dory or perfect in the Collegium system. In fact, I have, even not only in speeches, but I have said in a judgment, in a minority view in the Supreme Court, that I strongly believe that the retirement age of judges of the High Court and the Supreme Court should be the same. And this pain in the neck which many High Court judges get looking up to the Supreme Court will not afflict them if their retirement age is the same. So an argument is raised that if you raise the retirement age, many High Court judges may not want to come to the Supreme Court. And that is absolutely true. A Chief Justice exercises vast powers. Even olden days, very superb judges like Chief Justice M.C. Chagla refused to come to the Supreme Court. In fact, it was also hinted that he might be made Chief Justice of India. He says, I don't want to leave my High Court. So, but you will have judges with great administrative capabilities who can be left in the High Courts, and judges with a more intellectual bent of mind, but with less, administrative capabilities, who can be brought to the Supreme Court. So I agree with Justice Sodhi to the limited extent that and one of the solutions I have, the answer is not only to rake the problem, also a solution. For me, the solution is raising the High Court, the retirement age of High Court judges and making it par with the Supreme Court judges. And that will also solve another problem. In the next 3 years, if an amendment comes through, nobody listens to me otherwise, but if ever this serious thought is given to this issue, and the age of the High Court judges increased by 3 years, there will be no retirement for 3 years. You can keep appointing. And this 40% vacancy which we have can be drastically brought. And it will also see that I agree with Justice Sodhi to that limited extent. But I don't agree with him when he says the Collegium system is totally bad. I don't agree with him. Some of the best judges, I have also come to the Supreme Court through the Collegium system. There are so many, Justice Dhananjay Chandrachud has also come through the Collegium system.
Yes.
See, we are all products of the, but it needs improvement. There is no doubt about it that it needs improvement, and that improvement must come fast. Maybe one of the good fallouts of this battle between the government and the Supreme Court could be that the Supreme Court and the High Courts also improve the Collegium system.
Why do you say the improvement must come fast?
No, because these questions are being raised. You see, you were also asked, who was raising these questions a year back? Very few, far in between. Now these questions, it's in the public eye. We have to respond. And otherwise the state will come with another law like the NJAC.
So how do you
I'm not against, I've said it somewhere else in another interview yesterday, I'm not against having, like, not a government representative of the Collegium. But I in fact feel that when there is a tussle on a particular name, or there's disagreement on a name, then the law minister or the representative of the government can come and meet the Chief Justice and the members of the Collegium, maybe once in 15 days or a month, and have a discussion. And you can talk to each other and see, maybe the government may be right in certain cases. But if it is wrong, it can also be told, we are not going to. You see, yesterday, one is just Mr. The few days back, yesterday or day before yesterday, when the Collegium reiterated the names, one of the names reiterated is that of Justice Saurav Kirpal.
Yeah.
One of the names is of one gentleman from the Madras High Court, for the Madras High Court. And the allegation against him was that he shared an article which was critical of the Prime Minister.
Yeah.
I would say that even if he had written the article, he had only shared the article. But even if he had written the article, that was no reason for the government to disagree with his name if he is otherwise capable, otherwise his integrity is not in doubt. Justice Krishna Iyer was a minister in the left government in Kerala. He was appointed a judge, brought to the Supreme Court within 5 years of becoming a judge. He turned out to be one of our most brilliant judges.
These reasons that you mentioned that have been mentioned in the Collegium resolutions, do you think this is the Collegium just sending out a message to the center, or this is something which is a step towards transparency? Because one of the criticisms that is faced by the Collegium, like you yourself pointed out, is that it's too opaque. So do you think there's a continuing trend that we'll see?
I think it is a continuing trend, and it started in Justice Lalit's time. When in the last Collegium meeting, when the minutes of the last Collegium meeting were uploaded, which reflected the differences between the members of the Collegium also.
Within the Collegium, yes.
So if that could be put on in the public domain, what is wrong with putting, and there's nothing, is there some state secret involved in these things? The world knows. I have written an article about a year back about Justice Saurav Kirpal that as far as I know, there are only two things against him. One is his sexual orientation. Second is partner is Swiss.
Yeah.
So this was all in the public domain. What is new about it? And somebody sharing, I think that should be put in the public domain, because if this is a fact, and it is a fact, then you know what the government wants. It wants people who are not critical of it in this court.
Yeah.
Which means that they want people who will only toe their line. So what do you think would be better, the Collegium system or a system of the government appointed?
No, it's clear that they both have to work together, because like you said even earlier...
No, I'm not saying. You see, because why I'm saying you have to work together is that judges may not have all the material. We don't have the wherewithal to gather. See, even as Chief Justice, when I recommended names, I would also sometimes get unofficially call some senior police officials and try to find out, well, how's this lawyer, what is it doing? See, please understand that when we talk about the Collegium system, most Collegiums will not only follow the letter of the law, they'll talk to the senior advocates of that court.
Yeah.
While considering names of judges, and say, what is your view about the judges? They will consider, and it's not only the three members of the Collegium. I have always, whenever I have sent names, after the Collegium has considered, I've also considered the other judges of that court. Consulted them, may not be officially, but taken their views, because somebody may just give a background. No, this gentleman is not very honest. He has this problem. So you try and gather your input from various sources, and then so these are issues, and therefore the government even now plays a role, because when a name comes, it is sent to the government, and an IB report is given. The quality of the IB reports, we all know how good it is. There was a classmate of mine whose name was recommended for the Delhi High Court many, many years back. And the IB report came that he's a drunkard. He was nicknamed Boozer. Because, this is ironical. He was nicknamed Boozer because he did not drink. He was a teetotaler. So college mein uska naam kisi ne Boozer rakh diya, and that name stuck. And poor chap had to wait for another 5 years for his name to get.
Are you saying the IB reports in such cases cannot be
It
relied
can be.
upon?
You see, that is why I'm saying there's no harm in discussing the IB report also. You can't take it as the gospel truth.
Unless and until it.
I know of another case. These are all on record. This is the case on record where the IB report said that Justice so and so has said that this lawyer is totally incompetent. That IB report was not for a High Court judge, but for the Central Administrative Tribunal.
Okay.
And when the man filed a petition in the court, the judge said, I have never met anybody from the IB. Leave aside giving this recommendation, saying. So can we take it? You see, I'm not saying IB does a very good job. But just you criticize one or two judges who are black sheep in the judiciary, there will be a few in the IB also.
You can't take it on face value.
So it's not, can we say that everything is perfect in any institution? Not in the government, not in the judiciary, not in the IB. So we have to have a system of checks and balances where we cross-check.
So how do you see this proceeding? Do you think the best way forward is for the government through the parliament bring in a new form of an NGAC, or do you think they should?
I personally feel a new form of NGAC, if it is anyway close to the old form, will never succeed. But I see no reason why both the government and the judiciary cannot sit together.
Sorry, never succeed? Do you mean never succeed in the parliament, or never succeed when it faces the judicial scrutiny?
Will not succeed if in the manner in which it has been, if they'll have to come out with a very new system. I can't comment without seeing the law. I can't comment. But if it is anything like the NJAC, where the government had primacy, they had the right to veto, and you had two ordinary eminent persons on the panel without any definition of who are eminent persons. See, Sachin Tendulkar is one of my favorite cricketers, a very eminent person. Lata Mangeshkar ji was one of the most eminent citizens of this country, Bharat Ratna, both of them. But are they suited to appoint judges? Both my favorites otherwise, but I would not like them to have on a panel which is to appoint judges. So if you make, say, two eminent persons and you don't define who those eminent persons can be, then the eminent person can be the head of a political party.
So what do you think they should do?
No, I think as I told you, what Dr. Ambedkar said, you can never have a perfect system. Work together. Please tell me, in a country of more than 130 billion or whatever we are, if we sit together with only one interest in mind, that we have to choose the best judges. And we have no interest that I want my man. Whether it is I'm saying this to the judiciary also and to the government also. If your interest is not my man, my caste, my region, but your interest is only what is the merit and what is best for the institution of the judiciary, I think there will be no problem whatsoever.
That's great. Thank you so much, Justice Deepak Gupta, for speaking so candidly and taking out your time and speaking to us at India Today.
Thank you.
We hope to see you back sometime soon. Thank you.